Okay, good morning. I'm reading off some of my articles that I saved in my favorites. And, I don't know if everybody thinks it's a waste of my time, but I'm just doing this to help other people that don't know about these things. And if it helps one person, then great. If it doesn't, oh well. But here it is. It's foreclosure win. The administration of the justice outweighs the important interest in final of the litigation. Posted by Foreclosure Fraud on August 16th, 2016. Okay. The notion that MERS could not assign an ownership interest greater than that which it held rests on old age principles of property law, not on any recent development in our foreclosure jurisprudence. Jurisprudence. I don't know what that means. But, okay, so it says foreclosure win. The administration of justice outweighs the important interest in final fidelity of the litigation. I won my foreclosure case. The Maine Supreme Court has finalized my foreclosure case in my favor, citing that the administration of the justice outweighs the important interest in the finality of litigation. Imagine that, a court putting justice ahead of the policy and practice of a court not normally and sparingly and only a clear instance of previous error. Reopened issue of law already decided because they wanted to prevent a manifest injustice. Manifest injustice means something which is obviously unfair or shocking of the conscience. It refers to an unfairness that is direct, obvious, and observable. An outcome in a case that is plainly and obviously unjust. And in this case, because I didn't just sit on my rights but kept fighting and going on throughout the court system stating the same thing over and over again, that the bank didn't have that owned my mortgage deed due to the MERS assignment that only gave the bank the right to record, which not give them the ownership to prove standing to sue, because under Maine law in Saunders decided 28 months before my case, this argument was correct at the time and argued it in court, and that was overlooked by the Supreme Court, thus a clear previous error which is plainly and obviously unjust and unfair. They chose to reopen my case and correct their error and serve justice. From the order, in 2007, MERS, as nominee for Countrywide, purported to assign the mortgage to an entity called U.S. Bank National Association as a trustee for SAL 2006 through 3, and in 2009, that entity purported to assign the mortgage to the bank. I got U.S. Bank National Association, and that's the same year as all my stuff was happening, or before that, same years. Okay, the holder of the note. All right, so Reagan stopped making monthly mortgage payments in 2008. I never stopped making I get forced into two, I believe, fraudulent modifications through Bayview and Nation Star and now Caliber, but whatever. So Reagan filed a counterclaim alleging, among other things, that the bank did not have standing to foreclose because MERS had no right to grant or convey the mortgage to the bank and had no standing to grant, convey anything in its own accord, and that the bank committed various forms of fraud by initiating the foreclosure action anyway. So, hello. Sketchman, Halpin, and Savage. I don't know if I'm saying that right. The court, Fritzs, I don't know, held a trial in September of 2012 at which Reagan again argued that the bank did not have standing to foreclose. And on January 3rd, 2013, the court re-entered judgment in favor of the bank on its foreclosure claim, Reagan's counterclaim. The court then denied Reagan's motion for reconsideration. Reagan appealed, and citing our decision in the mortgage electronics registration system Inc. versus Sanders, 2010, Maine, argued the bank did not have standing to foreclose and MERS did not have authority to assign the mortgage. The court affirmed the foreclosure judgment in a memorandum and decision on December 24, 2013. See U.S. Bank National Association versus Reagan, and denied Reagan's motion for. All right. So in February of 2014, Reagan filed a complaint with the U.S. State District Court for the District of Maine against the bank and other defendants, claiming various constitutional statutory violations in connection with her case. After the court dismissed her complaint on October 2014, she appealed from the dismissal of the United States Courts of Appeal for the First Circuit. In March of 2015, in Maine District Court, Springvale, Reagan moved for relief from foreclosure judgment. She pointed out that the previous concerning MERS and her mortgage are identical to those that are in the issues of Sanders, in which the court determined they only have rights to convey to MERS or bear legal title to the property for sole purpose of recording the mortgage and corresponding right to record the mortgage at the Registry of Deeds. You know, I don't know why the Registry of Deeds here are not investigating, because there's a lot of counties suing MERS, and they're losing money by not having the regular recording fees and all that. So they're losing money in their own county. But yet, you know, they want to fight against somebody who's trying to expose this, which is, you know, what I was trying to do. But, you know, I guess that's not good. Okay, so after the Superior Court denied Reagan's motion, she initiated this appeal based on the unusual circumstances of the case. The court ordered Reagan to file a motion for extraordinary relief. Oh, okay, so that's what I gotta do. Extraordinary relief. Totally extraordinary. Okay. The court is convinced that the extraordinary circumstances of this case were an extraordinary relief. Instead of sitting on her rights, Reagan pursued every possible avenue for relief. At virtually every stage of the proceedings, she argued that the bank lacked standing to initiate the action because ownership interest in the mortgage stemmed from an assignment by MERS that was ineffective to convey the ownership interest required for standing. In this extraordinary case, the court concluded that the administration of justice outweighs the important interest in finality of litigation. It is therefore ordered that Reagan's motion for relief is granted. It is further ordered that the court memorandum of decision decided Reagan's first appeal at U.S. Bank. They just stole my home through Sketchman and Savage. Sketchman and Savage just stole my home, and they do it U.S. Bank, some stupid thing that they said they had, which is not true. Okay, let's see. It is further ordered that January 3rd, 2013 foreclosure judgment in the bank's favor was vacated, and the case is remanded to the district court for entry or dismissal of the bank foreclosure action without prejudice. Without prejudice. So, without prejudice, I don't know if that means... Okay, let's see. Wowzers. Thank you out there to my lawyer. Okay. Matthew Williams. Well, I wish I could find a lawyer that would kick ass, but I guess I have to do it myself. So here it is. U.S. Bank National Association. Some trust. Order of relief. See what people are saying. Okay, so it says, congratulations so far. However, it concerns me that the court ordered dismissal without prejudice. This is what I was going to say, because the bank will more likely move forward in getting their documentation order. Documentation, fraudulent documentation. Oh, and they say, oh, well, we'll just file an affidavit of lost note. Well, they've already given a note that's forged. So how are they going to do that? It says, but fight another day. Enjoy your outcome. Let me see. Here in Maine, the law was passed in 2015 due to a case is Bank of America versus Greenleaf, saying MERS assignment was invalid from okay. And these are all 2006. So these are all recently. Oh, excuse me. Well, thank you very much, Joe. It has a long, hard road, but support with friends and many prayers on my behalf finally was decided correctly. Keep up the fight. Justice can prevail, and I send you my prayers. They do work. Yeah, I'm not getting any support. I have one friend that's helping me through all this, and most of my friends have, I guess, I have too much problems in my life, so all my friends have bailed on me. My family doesn't really want to hear any of this, and I have no support except for one friend, so yay. So that's that. Many more to come.